The selection and arrangement test that you're talking about is really taken from, or largely based on, the Feist versus rural telephone case, which, as you say, the Ninth Circuit, actually no court has really applied that I know of to one of these literary infringement cases. So where you have what's called a combination of unprotectable elements, you carve down the elements of a screenplay or other type of literary work, and you look at that element to see whether it's protected, and then you find that it isn't because it's sans faire or it's a bare idea, then you discard it and there's nothing left after you do that. If you did the same thing for, say, a musical work, carve down the work down to the notes, obviously notes aren't protected, but the same result would happen, but that's not what courts do in musical cases or fabric design cases or sculpture cases or computer cases. Jay, why shouldn't courts apply the Feist test in this context as it does in all of those others?
I'm glad you asked me that question, Bob. First of all, I want to say a couple things. So, yeah, I'm here as Lucifer today, the agent of the dark side, and yes, I have spent a good portion of my career on the studio side. I should mention that studios, though, don't have a unilateral position about copyright infringement. I've certainly seen cases by studios against other studios. Studios can be plaintiffs in copyright cases, so they have no necessary agenda to weaken the concepts of copyright infringement. I've personally mediated a couple of cases involving studio versus studio comparison of films. Also, even though I've mostly worked on the studio side, I'm a songwriter. My wife is a screenwriter and writer and memoirist. I've worked for many authors over the years outside of the studio, and continue to do that to some extent. So that said, I'm here to be Lucifer today and try to advocate for this side of it. I assume that everybody understands the basic elements of the prima facie case of copyright infringement and how California describes what they're doing in these cases. Does anyone not know?
He wants to make like a professor. So
no, I'm just making sure. Okay, good. That's not surprising that everybody's familiar with that. Okay, so getting to the Feist and the selection, ordering, and arrangement idea. Feist was not this kind of case at all. In fact, the Supreme Court, as far as I know, has never handled a case taking on how to compare non-literally similar literary or audiovisual works. So I would love to see them take up on one of the Society's amicus briefs to take on a case like this, although, and I hope they wouldn't screw it up too bad. But that said, Feist definitely wasn't that kind of a case. Copying was admitted in Feist. There was no issue of copying. It was, in fact, what Nimmer would call comprehensive literal similarity. Basically, the entire work of the plaintiff was used by the defendant, and they pretty much admitted it. And even if they didn't admit it, there were several false names and phone numbers in there that were very striking similarity, evidence of copying anyway. But there really wasn't an issue. And Feist wasn't really about whether there was substantial similarity. Feist did not involve the type of issue that is our focus right now here, which involves at what level of abstraction does a similarity become more than one of ideas and becomes a similarity of substantial expression. Very intelligent judges like Learned Hand over the years have said that's a very difficult line to draw, and it sure is. And it's important because it's important to our society that ideas are free to be taken and free to be used and built upon. And in fact, pretty much every work builds upon prior works in some way, and may even involve a constellation of elements from prior works, although hopefully they're in the public domain. So it didn't involve non-literal similarity, and that's the analytical problem in these kinds of cases. And if anything, Feist dealt with the question of what's a compilation. And really what they were dealing with was whether the industrious labor that it takes to assemble data it was itself justification for copyright, and they said no, it isn't, rejecting a line of cases that said the opposite. And they said that only authorship is protected by copyright. What's authorship? And they proceeded to talk about authorship, and they found that there could, in the case of data, there could be a selection, ordering, and arrangement of unprotectable information or data that itself reflects sufficient originality to be protectable as a compilation. They noted that that protection is extremely what they call thin. It's basically protected only against almost literal verbatim identity, which is pretty much what they had in Feist. Unfortunately for the plaintiff in Feist, the actual selection, ordering, and arrangement of the plaintiff there demonstrated not even the tiny spark of creativity that's required for original compilations. So Feist, to me, is basically irrelevant to these cases.